Well, welcome everybody. We're going to be talking all about COBRA for this presentation, everything you wanted to know and more. We're going to talk about first which employers this actually pertains to. So this COBRA is actually, it's a federal law, but also it can differ a little bit per state. But the employers that are affected by this are employers that have 20 or more employees. So 20 or more full-time and or part-time employees. Those are the employees those are the employers that are subject to the COBRA regulations. So most group health plans are maintained by governmental employers are required to offer COBRA. However, group health plans maintained by churches are exempt from offering COBRA. And COBRA, of course, is the Consolidated Omnibus Reconciliation Act. And that allows employees who are no longer employed, whether it's voluntary or involuntarily, that they have left employment and they're able to continue coverage that they already had in place. So a qualified beneficiary that would be able to continue coverage would be an employee or a dependent who has been continuously insured under the group policy for at least 3 consecutive months before the qualifying event. When the qualifying event is a severance of the family relationship or the employee's retirement or death, then eligibility for a 3-month period of continuation depends on whether the family member had been covered for at least 1 year. So that means, in layman's terms, that a family is enrolled and there is a divorce, then the ex-spouse and dependent can continue to stay on the plan for actually 36 months instead of the regular 18 months. Infants under the age of 1 are not subject to the requirement of having to have been enrolled on the plan for at least a year. So in addition, any child born to or placed for adoption with a covered employee during the period of COBRA is considered a qualified beneficiary. So we have the example of, let's say, a female employee. They go on COBRA and then they have a baby, whether it's adoption or having the baby themselves, and that child would be able to qualify for COBRA as well. Qualifying events are events that trigger an obligation to offer coverage. They include a discontinuance of the group policy in its entirety, or termination of coverage due to a severance of a family relationship, such as divorce or legal separation, termination of coverage due to an employee's retirement or death, which the beneficiary at that point would be the spouse and or any dependent children, and other events that trigger an obligation are termination of employment for any reasons other than gross misconduct. I do want to emphasize something here regarding gross misconduct. I don't recommend that you make a decision as an employer based on what you consider to be gross misconduct. I one time had a situation where a client actually called the cops on one of their employees because they thought they had been taking money, stealing money is what they accused him of. And they brought in the police and he was escorted from the premises and they took him to court. And really he hadn't been found guilty yet. And so the case was still continuing. So I always recommend that you not determine what is considered gross misconduct, since it's also a very general term. And even if you think it is gross misconduct, I still recommend that the ex-employee be offered COBRA to just remove yourself from any kind of a situation, any kind of legal situation. Reduction in the number of hours of employment. So that means going from full-time to part-time. So you're a full-time employee, your hours are reduced, now you're part-time. You would be offered COBRA to continue the same plans that you had, where now you're responsible for 100% of the cost. And covered employee becoming entitled to Medicare. So an employee turns 65, decides to jump on Medicare, but their spouse and or child, of course the spouse, of course the child is under 65, so maybe the spouse is 60 years old, and so they're not Medicare age yet. So that would trigger a qualifying event for the spouse and the child to continue coverage while the employee is able to jump on Medicare. And loss of dependent child status under the plan. So this means dependent children. So dependent children can be covered under the plan up to age 26. So what happens is on the 26th birthday, if they're on your medical plan or dental or vision, their coverage cancels. So now they're no longer eligible, so they will actually get notified of their COBRA rights if they want to continue coverage. So the maximum duration of COBRA depends on the type of qualifying event. So 18 months is the standard. That's an employment termination or reduction in hours of work. 29 months would be if the Social Security Administration determines that the beneficiary is disabled during the first 60 days of COBRA coverage. This 11-month extension applies to the qualified beneficiary with the disability and all of the qualified beneficiaries in the family. Also, again, divorce or legal separation, an employee's death, entitlement to Medicare or loss of dependent child status would open up that 18 months to actually 36 months. And then 36 months after a qualifying event that is an employment termination or reduction in hours of work, a second qualifying event occurring that could be the death of the employee, a divorce, or legal separation would start another, would allow it to continue for another 18 months. So what happens to employers that actually have less than 20 employees? So employers that have less than 20 employees don't qualify for COBRA. They don't have to notify their employees of COBRA. However, they do need to let their employees know about their rights under state continuation. So state continuation would be that they're allowed to continue that coverage for 6 months. Now under COBRA, we have, again, you're an employer that has 20 or more employees, whether they're full-time or part-time. So after that 18 months, they'll actually be provided an opportunity to continue their coverage for an additional 9 months. So they must be offered up to a 9-month continuation period when coverage is lost for any reason other than termination of employment for cause. We're eligible for COBRA. Eligible employees, spouses, and dependents must be offered 6 months of continuation coverage following COBRA. COBRA coverage may end earlier than the maximum continuation period if premiums are not paid on a timely basis. The employer ceases to maintain any group health plan. So that's really important. So you may have an employee that leaves employment, elects COBRA, and the employer decides they're not going to offer medical coverage anymore. So when the plan doesn't exist, then there is nothing to offer anymore. So at that point in time, COBRA will end the day that the policy ceases to exist. The individual becomes eligible for similar benefits under another plan or program. So that also includes the individual marketplace. So healthcare.gov. So if an employee that is an ex-employee gets notified of their COBRA rights, they continue it, and then they decide, you know what, I think I might qualify for a subsidy under the marketplace and go get a policy there, and they do that, that will give them the opportunity to jump from COBRA to that plan, and then that would give them the opportunity to terminate their COBRA coverage. And then after the COBRA election, the beneficiary becomes entitled to Medicare benefits. This is also interesting when it comes to disability. So when a qualified beneficiary's COBRA has been extended due to disability and the qualified beneficiary is no longer disabled, coverage may terminate at the end of the maximum coverage period that applies without regard to the disability extension. Or if later, the first day of the month that is more than 30 days after a final determination by the SSA that the qualified beneficiary is no longer disabled. The notice requirements: when a qualifying event occurs, health plan administrators must provide an election notice regarding the rights to COBRA continuation to every qualified beneficiary. So every person that is enrolled on the plan before the qualifying event gets notified of their rights. So the employee, their spouse, their children, everyone gets notified of their right to continue COBRA coverage. There are so many days that must be satisfied for certain periods. So the first one is the employer has 30 days to notify their plan administrator of the qualifying event. So there are employers that manage their own COBRA administration, and there are employers that have someone else handle their COBRA administration, which I always recommend the second part, the second avenue, because you don't want to be a COBRA expert. You want somebody else to handle that, and especially since there can be legal ramifications, penalties involved if these days, if these requirements, if these notices aren't sent within the time frame that they need to be sent. So I always recommend that you outsource the COBRA administration. Through Integrity, we handle the COBRA administration through a third-party administrator, and it's in something that is fed straight out of our system. So everything happens once you terminate an employee, whether an employee resigns or you terminate them, involuntarily on their side. That is when that notice comes in, that separation termination form, and the employee is terminated in PRISM, then that notification goes straight out to our plan administrator. So we have 30 days to notify the administrator, but it's immediate. It's immediately. So, but we have 30 days. After that, the plan administrator has an additional 14 days to provide the notice to the plan participants and the beneficiaries of their right to elect COBRA coverage. So really, altogether, you've got 44 days after that date when the employee loses coverage. You've got 44 days to get that notice to the employee. 60 days from the qualifying event, the individual must respond to the notice and decide and elect COBRA coverage after, of course, they've been sent the notice. And after that, they have 45 days actually for them to make payment. So a participant can actually make payment later after they elect COBRA. And they have 45 days after the date of their COBRA election. So they have quite a bit of time. But the thing is when we add all this time up, we're talking about the time that by the time someone decides to elect COBRA and decides to make payment, they've got to pay several months worth. So they do have additional time to make COBRA payment, but at that point, they're going to be paying several months worth. When may COBRA premiums be changed? During a 12-month determination period, COBRA premiums may only be increased in the following 3 cases. COBRA premiums were set below the maximum amount permitted. So what happens is actually when an employee is offered to continue their coverage through COBRA, now they have to pay 100% of the cost, whereas before they were probably paying nothing or they were paying a small amount when it comes to medical. Dental and vision, maybe they were paying 100% of the cost. Well, the law allows the employer to add an additional 2% to the cost of the plan, because that's reimbursing the employer or the plan administrator for postage, for envelopes, for paper, for time, for administration. So that is why the premium will be different. If you're used to paying, if the employees are used to paying 100% of the cost, they'll see that the amount's a little bit higher. Actually, what's interesting on the second part here is that due to any kind of disability extension, remember an employee could have an extension for 29 months if they're disabled. Well, interestingly enough, you actually, as an employer, could actually decide that you wanted to increase the premium to 150%, which is kind of interesting, but that's a decision that an employer makes, and usually the decision is to just keep it at 102%. And the other way that the premium would change would be that the beneficiary has changed his or her election. So if an employee leaves, they were enrolled on a PPO plan with family coverage. But of course, the company was paying a portion of the cost. Well, now the company's not. So now the employee's faced with the family cost of a PPO plan, and it's 102% of the cost. So if the employee at that point could decide to say, well, you know what, I need to save as much money as I can. I'm mostly concerned about having myself on the plan right now. My kids are going to jump on my spouses or what have you. So I'm going to choose the HMO plan for myself. So that is the opportunity for the employee to change their elections when they make their COBRA elections. I do want to emphasize here also that COBRA participants must always be treated like an employee. And what that means is that when you as an employer go through open enrollment, you need to offer the same benefits and the same opportunity for your COBRA participants to make changes. So even if you are making no changes and it's the same medical, the same dental, the same vision, but there's maybe an increase in the medical premium, the COBRA participant must be notified and be given the opportunity. And that could also mean that you're having an enrollment meeting where all the employees are coming in. It could be a Zoom enrollment meeting, open enrollment meeting where all the plans are being explained. They do recommend that you also invite a COBRA participant to come to the meeting just like you would an employee, because you want to give them the same opportunity to ask questions and the same opportunity to make any changes. So what coverage must be offered to the qualified beneficiary? We're talking about medical, dental, vision, and FSA. Disability and life insurance do not qualify for COBRA. However, you can continue life insurance coverage. Most often than not, it's portable and sometimes even convertible. So when an employee leaves, they may be able to continue coverage, and they just need to notify the carrier that had the life insurance and let them know that they're no longer employed. Usually they have within 30 days to do that, and then they can decide to continue that insurance on their own. You know, all of the other benefits like hospital, accident, critical illness, legal, those are the kinds of benefits that are typically portable anyway. And what's going to happen is that when the employee leaves, they'll get notified of their rights to continue those plans on their own, and they're going to be asked if they want to just have the premium deducted out of their taken out of their checking account, let's say, on a regular basis. So FSA is in red because there's a couple of different things specific to the FSA. If an FSA is considered to be an accepted benefit, an employer will be able to limit COBRA coverage to the duration of the current plan year, and in some cases not be required to offer COBRA coverage at all. An FSA is an accepted benefit when all of the following conditions are met. The maximum benefit of the FSA, employer plus employee, does not exceed the greater of 2 times the amount of the employee's contribution or the amount the employee elects to contribute plus $500. If the employer does not contribute to the FSA, this requirement is automatically met. Group health insurance was available to the FSA participant during employment, and this coverage was not limited to accepted benefits, such as limited scope dental and vision coverage. And the maximum COBRA premium for 1 year's FSA coverage is equal to or exceeds the maximum FSA benefit for 1 year. This is usually the case, as an employer can charge up to 102% of the premium for COBRA coverage. When these conditions are met, an employer may limit COBRA coverage to the current plan year, even if the date falls short of the usual coverage period. In doing so, the employer avoids the scenario in non-accepted plans that would allow an employee to make a new election in the next plan year while still on COBRA. Additionally, with an accepted benefit plan, an employer would not be required to offer COBRA coverage at all to participants with overspent accounts. And the way that this works is, here's an example, that Joe elects to contribute $2,400 towards his FSA, and then he terminates his employment. He had contributed $1,200, which over the course of a year is $200 per month when terminated, and he hasn't used any of his balance. If he's entitled to, and he elects COBRA, he would continue paying $200 a month. And of course, that's after tax, because he's no longer being deducted through payroll. So now he's making that contribution after tax, plus the 2% COBRA admin fee, which would be his total COBRA premium. Joe would then have access to the full $2,400 while on COBRA and could terminate his COBRA coverage at any time. So the last thing I want to bring up here is that when your employees are enrolled on master plans that belong to Integrity, such as Humana, Options Plus, MetLife, even if you are a small employer that has 20 employees ordinarily, since you are on the master plans and you are, since you're under our master plans, which are under our EIN number, then you would actually fall under COBRA. Now, if you are a small employer that has less than 20 employees and you have your own plan, it could be Blue Cross Blue Shield, it could be United Healthcare, it could be Humana, it's your own policy that belongs to your company, then what happens at that point is you qualify, your employees are actually going to fall under state continuation. However, all that being said, Integrity uses a third-party administrator that handles both COBRA and state continuation. So even though it's your own group plan as a company, they are still administering, sending out those notifications and administering the elections and the premiums. And that is the end of this presentation. If you have any questions, of course, please do not hesitate to contact me.